welcome to a fresh episode of Legal Wrangle on indirect taxes. Today we are starting with an interesting Bombay High Court decision which has rejected the Delhi High Court ruling given in the case of Yum restaurants. Then we bring you the case relating to the claim of input credit on equipments installed for providing output service, custom duty payable on imported quantity exported to another country, issue of service tax notice and sales tax exemption on purchase of new machinery. In our first case, the assessees are multinational brands like Johnson & Johnson and ThyssenKrupp. They are engaged in export of services. In a batch of writ petitions filed before the Bombay High Court, assessees challenged the order passed by the Secretary Department of Commerce and Industry, holding that they were not entitled to the duty credit scrip under the Serve from India scheme as they were not promoting Indian brands. Let's have some details of the case.
The assessee contended before the High Court that the fact is it does not promote Indian brand or is not engaged in service which is expected to create a powerful and unique Served from India brand instantly recognized and respected world over is of no substance. Thus, the assessee had submitted the order of the Secretary in the Department of Commerce and Industry should be set aside.
The Bombay High Court ruled in favor of government and held that entity establishing a foreign brand of service prior to entry in India will not qualify and cannot be held eligible for Serve from India scheme benefit. The brand of such an entity is already created, existing and established, and it may not get instantly recognized and respected world over as Indian brand. As per the High Court, intention is to accelerate growth in export of services so as to create a powerful and unique Serve from India brand. The High Court further held that the single judge in Yum restaurant case failed to note that the parties like the assessee do not have a vested right in seeking or claiming incentives and benefits as duty credit scrips. It is only when assessee fulfills the criteria and the provisions of the nature carved out, then it would be entitled to the benefits. In our second case, the assessee, Vodafone India Limited, is engaged in the business of providing telecom services under the category telecommunication services in Mumbai. It had set up various equipments which were essential and integral part of the telecom service delivery across the world. The main equipment installed was base transceiver station which facilitated wireless communication between the customer's equipment and the main network. Let's move on to Neha for more details.
Assessee had availed SINVAT credit for duty paid on towers in completely knocked down, semi-knocked down form, parts of towers, shelter, prefabricated buildings purchased by them and used for providing output service. The statutory authorities were of the view that assessee was not entitled to avail SINVAT credit under the SINVAT Credit Rules 2004 and therefore show cause notices were issued. The Commissioner confirmed the demand therein along with the interest and penalty. On appeal before SISTAT, the order of the Commissioner was confirmed.
The High Court held that the case of Bharti Airtel Limited is fully applicable to the case of the assessee. It had also decided that an interpretation or a misinterpretation of statutory provision by one bench of the High Court would be binding on a coordinate bench of that very High Court. The subsequent bench cannot contend that a particular provision was misinterpreted and thus needs to be revisited. If that subsequent bench is of the view that statutory provisions are misconstrued or misinterpreted, the only recourse available to it would be to refer it to a larger bench. In the next case, the key issue is whether customs duty is payable only on the quantity received in India and not the quantity exported to another country. The assessee is Mangalore Refinery and Petrochemicals Limited, engaged in oil refinery. The assessee during the concerned year had imported crude oil vessel consignments. Now let's go to Neha for details of the case.
An order was passed stating that the quantity of crude oil mentioned in the bill of lading should be the basis for the payment of duty and not the quantity actually received in shore tanks in India, as duty was now levied on an ad valorem basis and not on a specific rate.
The matter was carried before the Supreme Court, where it was observed that for the purpose of assessment of customs duty, the value of goods can be determined only when such goods are offered for sale for delivery at the time of importation in the course of international trade. Thus, the levy of import duty cannot take place until goods are brought into India. The Supreme Court therefore held that the quantity of crude oil actually received into store tank at a port in India should be the basis for payment of customs duty. In the fourth case, the key issue is whether the issuance of notice can be equated with its service for the purpose of evicting an assessee from taking benefit of service tax voluntarily compliance encouragement scheme. The assessee during the concerned year made an application under the scheme admitting their service tax liability of about Rs 48 lakhs and paid 50% of the dues as mandated under the scheme. Let's go to Neha for the details of the case.
The said declaration was, however, rejected by AO, citing Section 106 of Finance Act 2013 on the ground that a show cause notice had already been issued to the assessee demanding service tax, and therefore it was not open to the assessee to avail the option of VCES. The Commissioner Appeal upheld this order.
The Sestat held that since the show cause notice issued under Section 73 of the Finance Act 1994 has not been served on the appellant before 1st March 2013, the impediment of Section 106 of the Finance Act 2013 regarding non-filing of declaration under Voluntary Compliance Encouragement Scheme will have no application. Thus, the notice which is merely issued cannot be equated to be served so as to be within knowledge of the assessee against whom it is issued. The Sestat further held that intention for incorporating such an embargo is to dissuade assessees against whom proceedings have been initiated from taking the shelter of Voluntary Compliance Encouragement Scheme. In our last case, the bone of contention is whether when the Financial Commissioner and Secretary in appeal has concluded that the condition precedent for obtaining sales tax exemption as regarding purchase of new machinery has been duly complied with by the assessee, it is open to the high-level screening committee to revisit such matter on another ground. The assessee is HPL Socomec Private Limited, engaged in manufacturing of switches and accessory. Let's see the details of the case.
The assessee had claimed eligibility certificate in respect of its new commercial production unit. The exemption was, however, denied on the ground that most of the fixed capital investment claimed was in respect of purchase of old machinery. The Financial Commissioner and Secretary Industries on appeal observed and concluded that the machinery were new at the time of purchase. However, the high-level screening committee sought to reopen the entire matter.
The High Court concluded that the screening committee has no jurisdiction to reopen the order passed by the Financial Secretary which has attained finality. The High Court further observed that the Secretary in appeal has concluded that the condition precedent for obtaining sales tax exemption as regarding purchase of new machinery has been duly complied with by the assessee, it is not open to the screening committee to revisit such matter on another ground. Well, this brings us to the end of this episode on Legal Wrangle on Indirect Taxes. You may write to us your comments, criticism and counsel at editor@tioltube.com. Please do subscribe to TIOL Tube to remain updated. It's free and will keep you updated on our new posts. Have a good day.